The next lecture to be given this afternoon is a lecture on consumer remedies, which will be given by Bruce McDonald. After Bruce got his law degree in Ontario in 1963, he did graduate work in the United States in the field of antitrust remedies. He was a professor of law at Queen's University from 1964 to 1970 and has been in practice in Toronto since 1970. A partner of the Lang-Michener firm in Toronto, Bruce practices principally in the fields of commercial litigation, administrative law, and competition law. Mr. Bruce McDonald.
The basic purposes of civil remedies have always been the same, namely to help implement the substantive laws by deterring offenders and by providing for restitution in cases of breach by means and to an extent that are consistent with social values from time to time. Remedies are the essential instruments of making the substantive laws acceptably effective. As society changes and the substantive laws change with it, adjustments and innovations in remedies and enforcement techniques follow if and to the extent that changes seem to be necessary in order to obtain the results we want. But there's usually a limit on the price that society will pay in terms of the nature of the remedies and the enforcement procedures that it uses in order to obtain a satisfactory level of compliance with its laws. One of the more important current questions, as I see it, regarding the nature of consumer remedies in Canada and the enforcement procedures that are used concerns the extent to which it is necessary or desirable to have the government take the initiative on behalf of consumers to achieve restitution. In other words, to assist consumers to overcome what have always been the fundamental problems with effective consumer remedies, namely the cost of obtaining them through procedures that might lend themselves well to other purposes, and also the problem of consumer ignorance regarding the remedies that are available to them. The basic characteristics of the remedies themselves have changed very little in recent years, although there's been a considerable evolution in this respect over a period measured in centuries. And so the Roman Emperor Zeno, you'll be absolutely fascinated to learn, he exiled people and seized all their property in any instances where they raised prices or monopolized in markets. In 14th century England, the limiting of supply for the purpose of raising prices to consumers was punishable by the forfeiture of goods for a first offense, the pillory for the second offense, incarceration and a fine for the third offense, and for anybody who dared to try it a fourth time, they were banished. On top of that, during the period of the Black Death, there was capital punishment added for such an offense. And in addition, the church added its own penalties of excommunication and the invalidation of wills. Now, if that sounds unduly severe by our modern standards, all you have to do is consult Section 26 of the Canadian Copyright Act, where you'll find that for commercial infringement, knowing infringement, that is to say for commercial purpose, you're liable to 2 months hard labor. I don't know of any instances under the Canadian Copyright Act where that penalty has been invoked, and I would expect to see it removed when the forthcoming revision bill is introduced. Anyone who has sought to advise clients who engage in nationwide retail commerce will be very conscious of the recent proliferation of a wide variety of new consumer protection laws in every province. what is it that has led, particularly over the last 15 years, to the amount of attention being paid to the general subject of consumer protection, consumer rights, and consumer remedies? Law reform commissions throughout the land are studying all aspects of the problem. Courts are challenged to reject or to supplement legal doctrines that have applied to the supply of goods and services since the 19th century and before. The apparent reason for this is that the consumer marketplace has undergone some unprecedented changes over the last decades, changes that have brought a mixed bag of blessings. The modern economy caters to a range of needs and desires that were unknown to our immediate ancestors. An enormous expansion in consumer buying and consumer credit has occurred. Everyday technology has become sophisticated well beyond the point of general understanding, and economies of scale have centralized production to the point where sources of manufacture are remote from point of purchase consumption. Media advertising plays an indispensable role in salesmanship. All this, together with growing degrees of specialization by everyone, has led to increasing ignorance on the part of the consumer about what he buys, and to a diminishing ability on his part to discriminate in his purchasing decisions, all without any laziness at all so far as he is concerned. This poses an important problem for an economic system that depends ultimately on the bases upon which consumers exercise their purchasing choices. It also raises questions about satisfying widely held concepts of fairness. A need for consumer remedy typically arises when a user of goods or services finds those goods or services to be deficient according to a socially accepted standard. He is paid for them, or he reasonably relies upon them, and he finds that they have caused harm or are not as satisfactory as they were represented or reasonably understood to be. It's also widely felt that special remedies are necessary to counteract high-pressure tactics in sales and in debt collections, to deal with deceptive or unfair sales practices, and to ensure disclosure of important facts. My main purpose on this occasion is to highlight some of the major recent substantive and procedural adjustments that have occurred recently in the law of consumer remedies. The subject of consumer remedies, as I understand it, is narrower than that of consumer protection, and accordingly a great deal of legislation dealing with safety and labeling and information requirements and new criminal laws will not be referred to. I also exclude self-help in the form, for example, of violence or boycotts, and official pressures such as the many forms of non-binding quality standards, most of which are instituted, or an increasing number of which appear to be instituted and formulated through the government. The scope of the survey is accordingly limited to recent developments in substantive rights and to procedural changes in the law that either make the consumer initiative to enforce his substantive rights more financially attractive or to reduce inhibitions to enforcement. A word might be said about the need for a socially acceptable balance in the general subject of consumer remedies. We're not limited to choosing between extremes, yet extreme views seem to be common on one side or the other of questions relating to consumer remedies, many of which, such as class actions, raise vexing issues of policy. This problem was described as follows by one scholar. He says, other problems derive from the failure of the legal system to adjust to the realities of mass production. It would not be in the best interests of consumers or anyone else if the manufacturing of consumer durables was aimed at achieving perfection in each unit. A point must be reached beyond which the marginal cost of preventing defects would exceed the marginal cost of suffering them, referring here to the total marginal cost to all parties. From a manufacturer's viewpoint, the downward pressure on prices that can derive from competition, as well as the desire to expand volume, militates against the use of the most durable materials, the most careful workmanship, supervision, and end-of-line inspection. Thus, the prices of consumer durables have been relatively stable, and the possession of, for example, cars, refrigerators, and washing machines has spread to wider sections of the population. Any over-insistence on durability and perfection might raise prices and thereby restrict volume to the detriment of consumers and workers as well as manufacturers. The sensible approach might well be to seek a level of performance that is acceptable and satisfactory on the whole, but which involves a regular proportion of defects. A crucial issue then is who should bear the loss when defects occur. Should the individual consumer take the loss as part of the luck of buying, or should the manufacturer assume the loss and allow for it in setting his price? Now, in the paper, I have touched on recent developments in the substantive law of contract and tort that are of particular interest to consumers, and I don't propose to review those at this time. They were included principally for purposes of completeness in the paper, and they're not an extensive part of it, but for example, with reference to new substantive rights in contract, I deal very briefly with Kravitz and Murray and Sperry Rand, and then deal with certain developments in the law of consumer products warranties that have occurred in Canada. Largely, it appears, as a result of the report of the Ontario Law Reform Commission on Consumer Warranties and Guarantees. The provinces that have enacted comprehensive consumer products warranties legislation as of now are Saskatchewan, New Brunswick, and Quebec. And these provinces are among the first jurisdictions in the English-speaking world to do so and to come to grips with what have been widely perceived to be hoary old problems in the law of sales that we're familiar with from law school that persist, some of them emerging from the Sale of Goods Act and others simply emerging from common law doctrines. Saskatchewan's legislation was passed in 1977, and it was the first of the provinces to pass the comprehensive warranties legislation. Saskatchewan appears to have relied fairly extensively on the Ontario Law Reform Commission report. Of course, in Ontario, Bill 110 died on the order paper in 1976 and has not yet been introduced with respect to this subject. Now, this is not the time or the place to attempt to describe the ways in which Saskatchewan, New Brunswick, and Quebec have attempted to deal with what are widely perceived to be these deficiencies. But each of these statutes, the three statutes, and each of them is unique in several respects, applies to most types of the commercial supply of consumer products. They provide for and ensure the existence of different categories of warranties and for remedies against manufacturers and other distributors. They provide these remedies in favor of subsequent purchasers as well as the original consumer purchaser. They discard the peril evidence rule, and they provide in detail for rejection rights. In the course of dealing with these matters, each of the statutes attempts to overcome or to ameliorate pre-existing problems of distinguishing contractual from non-contractual representations, conditions from warranties, and substantial from non-substantial breach. The one problem they do not appear to have been able to effect by statute is the need to draw lines between and to distinguish between reasonable and unreasonable interpretations or reliance. Experience will tell just what effect this new legislation will actually have in the marketplaces of the jurisdictions to which it applies. Certainly, there are many questions of interpretation that will have to be resolved by the courts, as there are with any new statute. As was commented recently in a review of the Ontario Law Reform Commission's recent report on the sale of goods, we may get a comprehensive, bright, shining, and well-oiled machine such as the proposed Sale of Goods Act, but that may not be of any use to a person who only wanted his bicycle repaired. Quebec's Consumer Protection Act, in which the new consumer products warranties provisions are contained in that province, goes well beyond what the legislation in either Saskatchewan or New Brunswick does in terms of its scope of coverage. With respect to remedies, it provides that if the merchant or the manufacturer fails to fulfill an obligation imposed on him by the Act or by the regulations, the consumer may, as a general rule, demand specific performance, a reduction of his obligations, rescission, or a declaration of nullity. There is further express provision made for exemplary damages. With respect to the relief of persons, including consumers, from unfair, onerous, oppressive, unconscionable transactions, there has been a good deal of judicial activity in the last 10 years or so, but it was capably surveyed in the special lecture series dealing with abuse of power by Mr. Mueller in his lecture on abuse of power in the contractual context, and I do not propose to deal with that subject here. There are, in each of the provinces, in addition, items of legislation that are very important to consumer protection, but with respect to which I believe most of you are generally familiar. For example, the laws dealing with direct sales practices, the cooling off periods, and so on under the Consumer Protection Act, legislation that by and large is common to all 10 provinces. In addition, there are a variety of remedies, including rejection rights and rescission, and damages and purchase price abatement in the Business Practices Act. 5 other provinces have legislation of a similar character, but again, that's a statute that has been around for a sufficient length of time that I don't want to dwell on it at this time. There's also a brief section, quite a brief section in the paper, again largely for purposes of completeness, dealing with matters of tort and the principles of liability they had against manufacturers in particular that have been recommended in the recent Ontario Law Reform Commission report on products liability. Apart from tort and contract and general principles of tort and contract, there have been some recent developments in the substantive field with respect to statutes conferring civil causes of action expressly upon someone who suffers harm as a result of an act that is contrary to the requirements of the statute. Without such provisions in statutes, of course, courts are left to make a judgment call with respect to each statute as to, with reference, of course, to the question of whether a breach of the statute creates or confers a civil cause of action on a person injured, and a court must generally ask whether the action is brought in respect of the kind of harm which the statute was intended to prevent, whether the person bringing the action is within the class of persons whom the statute was intended to protect, and lastly, and almost invariably most vexing, whether the special remedy provided in the statute was intended by the legislative body to be adequate for the protection of the person injured. I say there appears to be a recent tendency to avoid those difficult questions by simply dealing with the matter directly in the statute. Potentially, the biggest boost that consumer remedies have received in recent years by virtue of the establishment of a statutory right to sue where they have been harmed by an act that breaches a statute, was the enactment of Section 31.1 to the Combines Investigation Act, effective January 1, 1976. Prior to 1976, you may recall, it was widely believed that a cause of action could not be essentially founded on a breach of the Combines Investigation Act, although the recent lightweight aggregates decision in British Columbia has cast some doubt on that prior learning. By Section 31.1, any person who has suffered loss or damage as a result of conduct that constitutes a criminal offense under the Combines Investigation Act may sue for and recover from the person who engaged in the conduct an amount equal to the loss or damage proved to have been suffered by him, together with any additional amount that the court may allow, not exceeding the full cost to him of any investigation in connection with the matter and of proceedings under this section, close quotes. Part of the potential of Section 31.1 is evident from a review of the range of conduct that is defined as criminal under the Combines Investigation Act. It includes agreements or arrangements to limit competition unduly, whether with respect to price or other matters. It includes mergers that are likely to result in a lessening of competition to the detriment or against the interest of the public, quote, whether consumers, producers, or others. It includes the use of high degrees of market power to the detriment or against the interest of the public, quote, whether producers, consumers, or others. It includes false or misleading representations to the public for the purpose of promoting a business interest, including unsupported representations in the form of a statement, warranty, or guarantee of the performance, efficacy, or length of life of a product. It includes multiple ticketing and a host of items of retail chicanery that may not be of great interest to a consumer so far as civil recovery is concerned. Another offense involves promotional contests that are not operated according to statutory requirements. And of course, it also includes price maintenance. The civil cause of action created by Section 31.1 is independent of whether or not criminal proceedings have actually been instituted or a conviction entered. There may be an issue of the extent to which there are implications resulting from differing burdens of proof, which is to say that when you face the burden of proof of a criminal issue in a civil case, as it's sometimes described, the burden is theoretically defined as the civil one. My own personal view is that the different formulations between the civil and the criminal burdens of proof have virtually no practical significance to this question, because the formulations are in fact subject to large shadows around the definitions of both of them, and in fact there is, as I perceive it to be, and as stated by the courts, indeed a sliding scale between the two. So I would doubt that there's any strategic value to be gained by attempting to sue civilly, for example, before there may be criminal proceedings. Of course, one is not obliged to wait for the criminal proceedings. There is, however, a benefit in doing so if there's any likelihood that criminal proceedings are to be brought, because the statute does provide that where a person has been convicted of the offense, the record of proceedings in the criminal court is, in the subsequent civil proceedings for damages, and in the absence of evidence to the contrary, proof that the person against whom the action is brought engaged in conduct that was contrary to the statute, and any evidence given in those proceedings as to the effects of the acts or omissions of the person bringing the action is evidence thereof in that action. Now, obviously, it is not very likely that aggrieved consumers are going to stream into small claims court to claim small amounts of personal damages resulting from price fixing, merger, and monopoly offenses that have allegedly been committed. I don't see any lineups yet on the part of consumers to collect their proportionate share of the $15 billion the oil companies are alleged to have taken from us all. There may be some potential with respect to these and some very serious potential so far as the companies are concerned. Mergers, for example, might conceivably give rise to civil causes of action on the part of employees who have lost employment as a result of the reorganizations of the companies, or who have had pension rights or other employment benefits affected. And the other offenses have very serious implications, many of which have not as yet been, I think, brought home to many people, because it is only now that criminal prosecutions are in the courts for activity that has occurred after 1976. Of course, on January the 2nd, 1976, the civil cause of action would have meant very little, and all the prosecutions that were taking place related to conduct back in the early 70s and the late 60s. Nor are the consumers likely to stream into the small claims court to seek damages on the basis of possible offenses having been committed under the Act by organized labor. But again, it is a possibility under the civil action section. Problems of proof, even in the event that a conviction were entered with respect to offenses under conspiracy, merger, or monopoly provisions, would be so formidable as to inhibit recovery as an effective matter on the part of most individual consumers. The potential for recovery with respect to those offenses involving somewhat more complex facts than misleading advertising or price maintenance tend to involve may, however, be dramatically affected by developments in the law of class actions or by further amendments to the Combines Investigation Act that have been promised for the near future. There's also, as you know, a statutory cause of action for damages that exists under the Business Practices Act and the Trade Practices legislation. Another incidental item that I propose to touch on in the paper, but I will not deal with now, is the potential for a consumer remedy of the cause of action for unjust enrichment that was defined in Fibros and Fairburn in the House of Lords back in 1943. Now, that's a long time ago, and that's hardly a new development. But what is a new development, in my view, is what the Canadian courts have been doing with that principle over the last decade. The cause of action for unjust enrichment is an obligation imposed where the circumstances suggest that it is unjust or against conscience for one person to keep a benefit that has been obtained from another. And as I understand it, the Canadian courts have been much more willing to apply that principle than have courts in any other English-speaking jurisdiction. With respect to procedural matters, and on the procedural side, there are certain developments taking place to provide litigation assistance, if you like, to consumers who have proper causes of action. I'm thinking of the substituted plaintiffs provisions in the trade practices legislation of particularly British Columbia, Alberta, and Newfoundland, where the director under the provincial legislation can commence and maintain an action on behalf of a consumer. The other proposals to similar effect have been made federally, but do not appear to be going anywhere. It's with respect to this matter of litigation assistance that the recent developments in class actions are also relevant. And pending the Supreme Court of Canada's consideration of the Macon and General Motors matter that is currently before the court, I understand it's not yet been argued. There is very little to add to this subject with which you will not already be familiar. the policy questions underlying questions of class actions are I think, very important ones and perplexing ones, because, as you know, when collective proceedings for individually de minimis claims are involved, there is sometimes a special temptation to introduce unique rules of procedure that create special incentives to settle the litigation for reasons other than the merits. And such rules thereby have the practical effect of rules of substance. I'm thinking in particular questions regarding matters of notice, regarding the proof and quantification of damages, and rules respecting costs in the class actions context. Another aspect of consumer remedies that is touched upon in the paper, apart from litigation assistance, and there's also a slight note on restitution, obtaining restitution in the criminal courts, with respect to which some interesting provisions exist in the criminal code. Attempt to deal also with the other side of the coin, or in part the other side of the coin, is steps that have been taken to attempt to enhance the opportunities or the chances of a significant recovery for a consumer in an instance where he is held entitled to recover, and deal with various concepts of multiple damages, statutory minimum damages, such as, for example, were recently recommended by Mr. Justice Creever in his well-commissioned report on the confidentiality of health records, with exemplary and punitive damages, which are provided for in the criminal code of all places, also in the Business Practices Act, and with respect to which the courts are also, of course, willing to act. Another type of development in this general field of ensuring a recovery to a meritorious consumer claim has to do with compensation funds set up by way of guarantee under one or more statutes. Members of the Law Society of Upper Canada will be quite familiar from their own personal experience with compensation funds that are set up and financed by members in the industry to ensure recovery for meritorious consumer claims. Financial institutions have similarly lived with some years for such schemes. The two in particular that are commented upon in the paper, and I don't wish to do it now because I'm running out of time, have to do with the Travel Industry Act 1974, where a compensation fund is established and administered by a board of trustees, subject to appeal to the Commercial Registration Appeal Tribunal, to protect people who have paid travel agents or wholesalers for travel services that have not materialized. And the other example to which I was going to refer and is referred to in the paper concerns the Ontario New Homes Warranties Plan Act of 1976, with respect to which, as I'm sure you all know, there is a special seminar of the Law Society being held next week. Again, a scheme set up to protect, to a limited degree, the purchasers of new homes. That legislation, incidentally, might be profitably compared with a very interesting statute in the province of Quebec entitled the Building Contractors Vocational Qualifications Act, that deals in another manner, and a very interesting manner, with the question of protecting consumers of new homes, essentially through the technique of requiring contractors to come back for a license renewal once a year, and at that time to satisfy the board that they have not mistreated, in effect, any consumer who may be complaining in the meantime. The last type of remedy that I wanted to touch upon was the various attempts to obtain corrective action, positive corrective action from the suppliers. Any enforcement process naturally lends some encouragement to the consensual resolution of disputes. And this can lead to corrective action being taken in the form of, in instances rather where government agencies are involved in the enforcement effort, it sometimes leads to written undertakings or consent orders or other types of paper in the nature of, general nature of injunctions. These types of solutions, including the corrective action ones, tend to be highly desirable because they are generally satisfactory to both sides in view of their consensual nature. They are inexpensive, and usually they indicate a prompt resolution of a problem. Some statutes now contain specific provisions to achieve or to obtain certain types of corrective action. The new consumer products warranties legislation in Saskatchewan and New Brunswick entitles suppliers to cure certain defects as of right within a reasonable time where the breach is a non-substantial breach and where the consumer would not be inconvenienced. Another example exists in the Combines Investigation Act, which provides that it is a defense to a charge of misleading advertising, that in cases where the impugned act was an error and occurred despite due diligence in an attempt to avoid it, corrective advertising, if undertaken forthwith after such circumstances, given the existence of such circumstances, that will operate, such corrective action will operate as a defense to the charge of misleading advertising. I was going to deal very briefly with small claims courts and some developments there. I think the only one I'll mention at this time was the recent decision of the Supreme Court of Canada in the Nissan automobile case in Peltier, where a province was held to be constitutionally justified in excluding lawyers from small claims courts. That was the case, you may recall, of the redated Datsuns, where when a new model year came around, the distributor redated the cars in stock and issued them as new automobiles. And Nissan Automobile is now facing, as I understand it, hundreds of claims for $300 each. And they will be handled in the small claims court. I think at that point I will perhaps leave so we can have our coffee and get on with the next part of the program. Thank you.